Hi there. Greetings from Brussels. Europe is maybe not taking the lead on developing AI, but it certainly is taking the lead on regulating AI or artificial intelligence. As probably many of you know, at this very moment, the lawmakers in Brussels are negotiating the final details of the so-called AI Act. It's a piece of legislation that may impact any organization that is active in the field of AI, including companies that are based in the United States. The final text of the AI Act will be subject to a final vote by the European Parliament and the European Council in early 2024. Once the AI Act is adopted, there will be a transitional period until early 2026. This means that companies will have more or less 2 years to make themselves compliant with all those new rules on artificial intelligence. You may think this is still a long way to go, but it's actually not, because the rules will have an impact on how you develop your artificial intelligence and how you will bring it to the market. As an American company, as a US-based company, you might think it's not relevant to you. However, this is not true. The law has been written in such a way that it applies to any company that is developing, producing, selling, or using artificial intelligence, whether that company is based in the EU or not. As soon as a US-based company is doing business with Europeans or with companies based in Europe, the AI Act will apply. Another reason why you should know more about this European AI Act is the so-called Brussels effect, which has become an official term referring to the global impact of European legislation in other parts of the world. Think of the GDPR, the General Data Protection Regulation, which has now been copied in more than 100 countries outside of Europe. Europe believes it can repeat the success of GDPR with its AI Act. Brazil, for example, has already drafted a bill very similar to the European AI Act. Now, what does it do? Well, as said before, the AI Act covers the whole value chain of stakeholders: manufacturers, importers, sellers, users of AI systems. Depending on the impact an AI system may have on an individual human being, it is being classified as prohibited AI, high-risk AI, or minimal risk AI. Prohibited AI would be any system that is considered a clear threat to the fundamental rights of people. These are simply banned entirely in the European Union. Some examples of prohibited AI systems would be AI systems that manipulate human behavior and AI used to exploit vulnerable groups. For example, and this is an official example issued by the European Commission, toys using voice assistants encouraging dangerous behavior of minors, or systems allowing social scoring by governments or companies. Or another example, emotion recognition systems used at the workplace, surveying employees. Or real-time biometric identification for law enforcement purposes in publicly available spaces. Or untargeted scraping of facial images. These are all examples where the European Union believes that it is a prohibited use of artificial intelligence and it risks or it is classified as a prohibited AI system. So that's the first class of AI systems. What is then the second one? Well, it is called high-risk AI. In short, this is anything that could have a significant impact on the health, the safety, and the fundamental rights of people. Now, to make it easy, there is an annex to the AI Act summing up what is actually high-risk AI for sure. Think, for example, of the use of AI in robot-assisted surgery, AI-enabled medical devices, but also CV sorting software for recruitment procedures or credit scoring. They're all considered as high-risk artificial intelligence. Well, if you're active in this field, you will be confronted with many obligations and red tape before doing business in Europe or with Europe. One of those obligations is that you will have to go through a conformity assessment. This would be a self-assessment, but in specific cases, the assessment should be done by a third party, by an auditor. And you will assess, or you will be assessed on security requirements, on the use of data, but also on the impact of the AI system on fundamental human rights. And finally, you're going to have to mark your AI system with a CE mark, something we already know for other products that are put on the EU market. Think of toys, devices, cars, whatever. So that about that second class of AI systems, the high-risk AI. Next to prohibited AI and next to high-risk AI, the AI Act also introduced some transparency obligations for AI systems that do not really impose a high risk, but they do interact with human beings. Think of a simple chatbot that would assist you during an online ordering process. Well, this type of AI does not have to meet specific requirements, except that people should know they're communicating not with a human being, but with a computer, with artificial intelligence, so that also the information has been produced using AI. And this type of AI system, or the risk qualification related to that, is called the transparency risk AI. And finally, at the bottom of the AI risk pyramid, there will be the so-called minimal risk AI, which is not regulated. This actually should be the majority of AI systems, such as AI-enabled video games, spam filters, you name them. These are not regulated, but companies are invited to draft codes of conduct for those AI systems. Now, just a word about generative AI. The initial draft of the European AI Act was submitted before the hype around OpenAI and generative AI in general. Well, the European Parliament now, they successfully introduced some very specific obligations for what they call general purpose AI systems. The most important obligation generative AI service providers will have to follow is to share with the end user the sources they've used for producing the AI generative results. This will not only give transparency about the sources being used, but it will also give the possibility for right holders to know whether or not their copyrighted content has been used, so that the relevant royalties can be paid, or in case no permission was given, the right actions can be initiated. For models that could pose systemic risks, there will be additional binding obligations related to managing risks, etc. We will see how it goes. We don't have the final text yet. But what we do know for sure is that Europe is not Europe without enforcement. Yes, also in this act, supervisory authorities are going to be set up at state level, so at national level, and they will have enforcement power. Non-compliance with the AI Act can lead to fines ranging from 7.5 million euros to 35 million euros, so even more than GDPR infringements. Could also be a percentage of the global turnover, from 1.5 to 7% of the global turnover, depending, of course, on the infringement. And next to the local supervisory authorities, we're also going to have a kind of super AI office, the so-called European AI Office, which will supervise the implementation and enforcement of the new rules on general purpose AI models. And as the European Commission in its press release boldly stated, this AI office will be the first body globally that enforces binding rules on AI and is therefore expected to become an international point of reference. So please stay tuned. We will know much more about the final text of the AI Act and the very precise and detailed consequences for us as companies active in artificial intelligence. Thank you very much.